Namaste, respected members. A great welcome to 2025 and a warm send off to 2024. Now, let us have a very quick look on the various judgments delivered by the Honorable High Courts during the year 2024. Some landmark judgments I would like to present before you. I got this information from the Taxman website. Around 25 landmark judgments delivered by the various honorable high courts governed by the Taxman website. So I would like to present the same. The first one is a landmark judgment from the Honorable Supreme Court. Construction of immovable property may be considered as plant for claiming ITC if it is a critical to business operations. This is citation is Chief Commissioner of Central Goods and Services Tax and others versus Measures Safari Retreats Private Limited. I once again read the headline. Construction of immovable property may be considered as plant for claiming ITC if it is critical to business operations. So this is in favor of the dealer. Next one is no interest liability if assessee deposited GST amount within due date but filed returns belatedly. This is from the Honorable High Court of Madras in the case of Eicher Motors Limited versus Superintendent of GST and Central Excise ranging to no interest liability if assessee deposited GST amount within the due date, that is maybe 20th of the succeeding month, but filed returns belatedly. This is also in favor of the dealer, assessee, taxpayer. Next, interest liability arises automatically on delayed filing of returns, even if payment made from credit ledger. This is from Patna High Court in the case of Simcon Infrastructure Private Limited versus Union of India. The earlier citation is Eicher Motors. Now this is from Simcon Infrastructure from Patna High Court. Interest liability arises automatically on delayed filing of returns, even if payment made from the credit ledger. So this is in favor of the revenue. Next from Kerala High Court. High Court placed a matter before division bench to decide whether state tax authority can issue show cause notice under GST Act. So there is no favorable judgment either in favor of the department or in favor of the dealer. Matter referred to division bench from the single judge in the case of Pinnacle Vehicle and Services Private Limited versus Joint Commissioner, Intelligence and Enforcement. So Honorable High Court placed a matter before the division bench to decide whether the state tax authority can issue show cause under the CGST Act. So now still it is debatable issue. Next, in the case of Bharti Airtel versus Commissioner CGST appeals, Delhi High Court, Honorable Delhi High Court held that telecom towers are mobile properties as they do not meet the test of permanency and ITC on same cannot be denied. So this is also in favor of dealer Bharti Airtel Limited. Telecom towers are mobile properties as they do not meet the test of permanency and ITC on same cannot be denied. So favorable judgment from Honorable Delhi High Court. Next, from Telangana High Court in the case of Prahita Construction Private Limited versus Union of India, transfer of development rights of land by way of JDA should not be treated as sale of land by land owners. This is from Honorable High Court of Telangana. Transfer of development right of land by way of JDA should not be treated as sale of land by landowner. So, in favor of revenue. Claiming of ITs and the wrong head is only a technical mistake committed by the assessee. Reziman Padikka Parimbil Alex versus Union of India. Kerala High Court held in favor of the dealer. Again, claiming of ITs and the wrong head is only a technical mistake committed by the assessee. Next, disallowing ITC for late returns is arbitrary as late fee and interest serve as sufficient deterrents. Madhya Pradesh High Court in the case of Honest Steel versus Union of India. This is also in favor of the dealer. Dissolving ITC for late returns is arbitrary as late fee and interest serve as sufficient deterrents. Already late fees and interest is charged on the dealer. Again, dissolving ITC is not a correct one on the part of the government. So this is also in favor of the dealer. Next, in the case of KT, Said Alvi versus State Tax Officer, Honorable Kerala, initiation of any inquiry or summons under CGS Act cannot be considered as initiation of proceedings. So this is in favor of the revenue. Initiation of inquiry or summons under CGST Act cannot be considered as initiation of proceedings. So you must attend the summons, etc., etc. Next, Rule 96 Sub Rule 10 is ultra vires to Section 16 of the CGST Act and unenforceable on account of being manifestly arbitrary. This is in favor of Vinayaka Cashew Company versus Union of India. This is also from Kerala High Court. Rule 96 Sub Rule 10 is ultra vires to Section 16 of the AGST Act and unenforceable on account of being manifestly arbitrary. Now I touched nearly 10 judgments, some in favor of department and some in favor of dealer, and remaining 15 judgments I would like to take up in my next video. Kindly watch the further videos also. Till that time, goodbye once again. Happy New Year to one and all. Thank you. Thank you very much.